There will now be an opportunity for silent prayer or meditation. Please be seated. Honorable members, we have all learned with shock of the passing of the Honorable Ms. T.M. Jumat Peterson on Monday, the 5th of June, 2023. We would like to express our heartfelt sympathy as we stand with the family in this difficult time. The House will schedule an appropriate motion to express its condolences in due course. I thus request you now to stand and observe a moment of silence in respect of the honorable member. Thank you. You may be seated. Honorable members, the first item on the order paper is a motion in the name of the Chief Whip of the Majority Party. I now recognize the Honorable Chief Whip of the Majority Party.
Thank you very much, House Chair. To all honorable members of this august House, I hereby move that the following item. The following item that was on the order paper and which in terms of Rule 351 lapsed at the end of the last sitting day of the 2022 annual session be revived for consideration by the National Assembly. That is the report on Committee on Mineral Resources and Energy, the Portfolio Committee of Home Affairs, and the Portfolio Committee of Police on joint oversight on illegal mining to 5 South African provinces. I hereby move, Honorable House Chair. Thank you.
Thank you, Honorable Chief Whip. I now put the motion. Are there any objections? No objections agreed to. The Secretary will read the first order of the day.
Consideration of recommendation of candidate for appointment by the President to serve as Commissioner for Public Service Commission.
I now recognize the Honorable Ngweba, the chairperson of the committee, who will introduce the report.
Thank you very much, House Chair and honorable members. The National Assembly is obligated in terms of the Constitution of the Republic of South Africa and the Public Service Commission Act number 46 of 1997 to recommend a candidate for the appointment by the President to serve as a commissioner for the National Public Service Commission. House Chair, Section 196 of the Constitution empowers the National Assembly through its committee to appoint 5 commissioners for the National Public Service Commission. Each commissioner should serve for a period of 5 years, which is renewable term. The committee received a request through the Speaker's office to expedite the filling of vacancy for the commissioner post in the National Public Service Commission. On the 9th of December, 2020, the committee placed an advert in various national newspapers calling on members of the public who are fit and proper persons to apply for the vacancy in the PSC. Honorable members, the Portfolio Committee appointed among its members a subcommittee to run with the recruitment process and report back to the principal committee once the recruitment process are completed. House Chair, the 69 applicants responded to the advert, and most of the candidates who responded have requisite skills and experience to contest for the position. Candidates were shortlisted based on their previous background, knowledge, and experience in various institutions. The principle of fit and proper means that a person must show integrity, reliability, and honesty, as these are the characteristics which could affect the relationship between such a person and the public. House Chair, in shortlisting, the committee has ensured inclusion of people with disabilities, women, youth, form part of the shortlisted candidates. And the committee resolved to shortlist 7 candidates for the interviews. And however, 1 candidate withdrew from the process prior the date of the interviews. And all shortlisted candidates were subjected to security clearance by the Department of State Security agents to guide the process in determining or ensuring fit and proper person get recommended for the appointment by the president. And the report tabled in this August House took into consideration the vetting report by the state security agents. House Chair, the Portfolio Committee on the Public Service and Administration unanimously resolved to recommend that the House recommend candidate Mr. Errol Vincent Mekamen for the appointment by the president to serve as a commissioner for the National Public Service Commissioner. Honorable Chair, I therefore move for the adoption of this report. I thank you.
Thank you, Honorable Member. I will now recognize political parties wishing to make a declaration, the opportunity to do so. The usual time for declaration of votes will apply. The DA.
House Chairperson, the Constitution and the Public Service Commission Act are silent on the requirements for the senior position of National Commissioner at the Public Service Commission. This gap or void in the relevant legislation has resulted in the criteria for the shortlisting of candidates for this position being largely left to the subcommittee tasked with recommending a candidate. In this instance, House Chairperson, the criteria agreed upon by the subcommittee included that an applicant should have extensive knowledge and understanding of the public service and the Public Service Commission, and further have the relevant or appropriate experience at a senior management level in either the public or private sector. Also agreed upon by the subcommittee House Chairperson was that an applicant should also possess the appropriate and relevant qualifications in relation to the core mandate of the Public Service Commission. House Chairperson, if the truth were to be told, it would be that Mr. Mahaman was most certainly not the best performing candidate in the interviews. On the contrary, he was one of the poorest or worst performing candidates in the interview. Simply put, House Chairperson, Mr. Mahaman failed in his interview to demonstrate to the subcommittee that he has extensive knowledge and understanding of the public service and the Public Service Commission. What is also true, House Chairperson, is that Mr. Mahaman does not have the appropriate or relevant work experience, as he has spent the better part of his adult working life in the employment of the ANC. In actual fact, he cites the ANC as his employer more than 7 times in his curriculum vitae. The third and final truth, House Chairperson, is that Mr. Mahaman does not possess the appropriate and relevant qualifications in relation to the core mandate of the PSC, given that his highest and probably only qualification is an advanced certificate in governance and public leadership from WITS, which qualification has little or no bearing on the core mandate of the PSC. House Chairperson, there were definitely better performing candidates that met the agreed criteria and outperformed Mr. Mahaman by far in their interviews. One of those candidates, House Chairperson, is a PhD holder with solid experience in the field of monitoring and evaluation, a field, House Chairperson, that I can guarantee you is both germane and essential to the mandate of the PSC. The candidate in question also boasts extensive work experience in the public service and has previously worked at the Public Service Commission as the Deputy Director responsible for monitoring and evaluation. And whilst working at the PSC, this particular candidate, House Chairperson, contributed towards report writing, research, and further developed monitoring and evaluation tools for the PSC. Another candidate who also stood out during the interviews, House Chairperson, has read law at WITS and also previously worked for the PSC as its Chief Director for Labor Relations and Legal Services. In addition to working for the PSC, House Chairperson, this candidate has held senior positions at notable institutions such as the Office of the Chief Justice and the Office of the Public Protector. Allow me to emphasize, House Chairperson, as I did during my recent budget vote speech, that the PSC is a knowledge-based institution and not a political institution. Moreover, the framework towards the professionalization of the public service demands that the PSC, which is independent and impartial in its mandate and functions, be staffed by competent, experienced, qualified persons who can actively contribute towards its existing knowledge base. This then begs the question, House Chairperson, as to what kind of knowledge and experience Mr. Mahaman will be bringing to the Public Service Commission if this report is adopted today by this August House. The answer is that the only experience and knowledge that Mr. Mohammed has and that he will be bringing to the PSC is that of being an ANC cadre. Mr. Mohammed, House Chairperson, is an ANC cadre through and through. An ANC cadre, whom I must add, has just a few days ago taken up a seat at the Gauteng Provincial Legislature as an MPM. House Chairperson, let him remain at the Gauteng Provincial Legislature. Cadre deployment has already done so much damage to our public service administration, and we simply cannot afford it to allow it to also compromise and taint the independence, impartiality, and dignity of what is the last hope for our public service administration, that is the PSC. House Chairperson, I would be failing in my duty as a legislator if I did not urgently call on the Minister of Public Service and Administration to ensure that when the PSC bill is tabled in Parliament, it contains a provision on the minimum qualifications, skills, and work experience of commissioners, as this will assist in ensuring that only qualified and deserving persons are recommended for the senior position within the commission that commands an annual salary of almost 1.6 million rand. If this is not done, House Chairperson, decisions on who to recommend as commissioner to the PSC will continue to be left to an ANC-dominated subcommittee whose mandate is one thing only: to deploy cadres seeking deployment to the PSC. I thank you.
The EFF. The EFF. The IFP.
Chairperson, good afternoon, Honourable Chairperson and the House. One chairperson, one needs to contribute to the appointment. The IFP has consistently been of the view that people working within a public service must be representative of the people of our country with the relevant skills to support public service comments. Our parliamentary leader, His Excellency Prince Buthelezi, the founder of the IFP, has maintained that it is only servant leadership that will drive South Africa's development of its government and public service. Servant leadership in government is not employment that merely fulfills the need for salary, status, and benefits. It requires individuals who have belief, foresight, and commitment to always act in the interest of the state. Honourable Chairperson, unfortunately, South Africa has, over the past few years, witnessed firsthand what can happen when certain sections and people within the public break down principles of trust and lose sight of commitment to the citizens of the country. The need for a commissioner in the public services of utmost importance, as the Public Service Act on behalf of the people of South Africa to maintain oversight of government programs. The appointment of the Public Service Commissioner must ensure that service delivery across the board is not only maintained but improved in all sectors. Public service delivery is part and parcel of ensuring that the people of this country are able to achieve and access their right contained in Chapter 2 Bill of Rights in our Constitution. The IFP is encouraged that the committee decided to seek out the legal interpretation of a fit and proper person, which compels their understanding when interviewing candidates that a person must show integrity, reliability, and honesty. These are standards and norms by which government must interpret any act of an employee in order to increase the trust relationship between the public and the government. It is important that our commitment to constitutional values is no longer seen as something that we will aspire to put, rather should be something that we actively start breathing life into. Or speak, Chairperson, I'm sorry. The appointment of a new public service commissioner must see a marked change in the way government operates when it comes to holding employees.
Honourable member, your time is now expired.
So
EFF
far,
Plus.
and in the zone of in the wake of the Zondo Commission.
The
We
FF
don't
plus,
support the candidate. Thank you.
Thank you, House Chairperson. Just another partisan appointment, a cadre appointment, and once again, the fit for purpose candidate is not being considered. Has the ANC and this government not learned? This is totally unacceptable, and the Freedom Front Plus rejects this appointment. I thank you.
the ACDP,
Thank you, House Chair. House Chair, the ACDP is also concerned about the appointment of the nominee, Mr. Margaman, and we believe it will compromise the impartiality and independence of the Public Service Commission. It also, in our view, flies in the face of government's commitment to professionalize the public service and build a capable state. Certain members of the committee hold the view that Mr. Margaman does not hold the necessary qualifications, skills, and work experience to occupy this senior position. And this appears so, as according to his CV, his highest qualification is an advanced certificate in governance and public leadership. And it appears that outside of this qualification, he has no other experience and has worked only as an ANC cadre in various ANC positions, including elections coordinator, councillor, and now ANC member of the Gauteng Provincial Legislature. Chairperson, the Zondo State Capture Report found that the ANC cadre deployment policy violates 5 different subsections of the Constitution, as well as contravening the Public Service Act, the very act we are dealing with at the moment. This legislation says that no appointment, promotion, or transfer may be made or effected or decided upon outside the prescriptions of the legislation, and that those prescriptions are equality and other democratic values and principles enshrined in the Constitution. These values of equality are in the treatment of candidates, transparency, accountability, and fairness. The report further found that there's no mention of membership of a political party, including the ANC or current ruling party, nor is there any mention of a recommendation made by the deployment committee of the ANC or any political party. That is in the legislation. The report found further that it envisages a public administration that maintains a high standard of professional ethics that is efficient, economic, effective, impartial, fair, equitable, and without bias, and that the governing party's deployment policy was counter to all 4 values that guided political administrative interface. Despite this indictment, the ANC continues in its deployment policy that has had such a detrimental impact. They believes that there were far more deserving candidates and therefore will not support this report. I thank you.
the UDM, the UDM, the ATM, good,
House Chair, we have no declaration. Thanks.
yeah. The NFP,
Thank you, House Chairperson. House Chairperson, the NFP does not have a problem if an applicant belongs to any political party, because it's expected that all applicants, employees will at some stage belong to some political parties. And that's the norm across the board. What we have a problem with, however, Chairperson, is the fact that despite not having the necessary experience and qualification for this particular post, more importantly, during the interview process, it was established that there were other applicants that had the necessary qualification, had more experience, and that were overlooked. And the NFP believes that in order to ensure that the Public Service Commission appoints those that are responsible and that will be able to be fit for purpose, that we need to take that into consideration. The NFP finds it very difficult to support this on the basis that we believe that those that were actually interviewed proved to be much better candidates in this case. So the NFP will not support this. Thank you.
the AIC,
Chairperson, the Public Service and Administration Portfolio Committee's endorsement of the candidature of Mr. Errol Vincent Megaman as the preferred candidate for the Public Service Commission must be understood against the mandate of the Commission. Other considerations to be considered are his experience and qualifications. The Commission is a creature of statute and was established by the Constitution in terms of Section 196. It is common cause that the foundational values of responsiveness, accountability, and the rule of law under the current Constitution require us to install an efficient and people responsive state administration struggling in all spheres of government. All organs of state, inclusive of state departments across all spheres of government, must comply with the public service precepts. This is where the Commission comes in. It must champion the values of respect, integrity, accountability, and responsiveness across the state administration. It is this mandate that Mr. Megaman must carry out as a commissioner. Having largely working for the African National Congress and various government agencies, it behooves us to ask whether he is a fit and a proper person for the job. In other words, is he going to display an independent mind and advance the best interest of all South Africans, irrespective of their political affiliation? Can he instill confidence in public service through ethical behavior, honest and integrity? Does he exhibit personal integrity and ethics in his professional conduct? These are difficult questions, but principle will guide us. Mr. Megaman, as candidature, must never be undermined merely on the strength of his affiliation to the ANC. There is no doubt that his extensive work experience will likely enrich the work of the Commission. Nothing tangible has been provided to us to vote against this candidate. And because we believe in fairness and the integrity of this process, we will support this candidate. We have sought to balance experience with sound public administration. I thank you.
Thank you, Honorable Chair. Having gone through the CV,
All honorable members,
I say having gone through the CV, the experience and the qualifications of the candidate, we rise to support. Thank you very much.
the PAC,
House Chair, point of order, House Chair.
the PAC,
Honorable Chair, the PAC supports the nomination.
Al Jama.
Point of order, House Chair.
What is the point of order?
Chair, I've been having problems logging on due to the network problems. Is there a chance that I could do the
I'll come back
EFF?
to you. Thank you.
Thank
Al
you.
Jama. Al Jama. The EFF.
Thank you very
The
much,
EFF.
Chairperson. Thank you, Chairperson. Chairperson, may I start by greeting the Commander-in-Chief and President of the EFF, Julius Salo Malema, officials, commissars, and the ground forces of the EFF. Chairperson, as the EFF, we mark a 10-year milestone. We continue to build government and state capacity, striving to appoint individuals to positions based on merit and capability rather than merely rewarding known entities, thereby reducing the potential for corruption. Chairperson, the PSC is a knowledge-based organization that produces information contributing to a participatory and developmental public service. It is for this reason that we had to remain impartial in appointing a capable, ethical, and competent individual to this crucial institution. In making our decision, we took into consideration various factors, including gender, individuals with disabilities, and youth representation. Above all, however, we had to choose the most suitable candidate for the position to ensure a functional public service commission. Chairperson, the EFF as an organization are satisfied that the proposed candidate meets the necessary standards and capabilities. Therefore, we support the nomination presented today for appointment to the position of Public Service Commissioner. During the 6th Parliament, our committee had appointed 4 commissioners, amongst whom there is representation of youth, women, and individuals with disabilities. We support this appointment because it was merit-based. Chairperson, this selection process was one of the most challenging we have undertaken. We had to choose one candidate from more than 100 men and women, many of whom had the required skills and capabilities. However, only one individual could fill this position. The subcommittee faced the task of selecting the most suitable candidate, narrowing down the pool to 7 candidates. After intense and thorough interviews, only one candidate was appointed, Mr. Vincent Errol Magaman. As the EFF, we noted the seemingly selfish and racially driven attempt by the Democratic Alliance during the process to impose their preferred candidate, even after the subcommittee had agreed on the number of candidates to be shortlisted. We wish Mr. Magaman well in his new responsibilities, but also wish to caution him that assuming this role does not provide a license to be corrupted by the government of the day, he should know that he is joining a team of hard workers that is expected to add value and contribute positively to the work done by the commissioners he is joining. Thank you very much, Chairperson.
ANC.
Thank you, House Chairperson. House Chairperson, I want to remind this House that whenever conducting the interviews, the scoring is not about an individual. It's about the scoring of the panel. And the bone of contention is with vetting. The matter ends there, and the rest is history. Chairperson, Chapter 10 of the Constitution has embedded institutions which support our democracy that are critical in providing independent perspective and make recommendations to enhance the objects of the Constitution. Public service plays a critical role in having a capable developmental state which can harness the nation's resources for the realization of the objectives of the Freedom Charter and our institution to create an equitable and prosperous South Africa. The Public Service Commission plays a crucial role to investigate, monitor, evaluate the organization and administration and the personal practices of the public service, to propose measures to ensure effective, efficient performance within the public service, to give directions aimed at ensuring that personal procedures relating to recruitment, transfers, promotions, dismissals comply with the constitutionally prescribed values and principles. To report in respect of its activities and the performance of functions, including any findings it may make and directions and advice it may give. These are some of the key functions of the Public Service Commission. Our duty to support and contribute on the resourcing of the Public Service Commission is central in responding to priority 1 of the medium-term strategic framework. As the ANC, we have participated in the process for the appointment of the commissioner as a function of the parliament for consideration by the president. A critical principle which has shaped the process is ensuring that we appoint persons who are fit and proper and persons who have a record of integrity, reliability, and honesty. An ethical public service is an imperative recognizing the challenges affecting the public service. Fighting fraud and corruption in government requires a public service which is protected through whistleblower protection and instilling ethical practices and conduct in the public service. Recommendations and directives from the Public Service Commission have enhanced the public service and highlighted key areas which require the intervention of government. In accordance with the criteria for shortlisted candidates, the committee resolved to recommend Mr. Errol Vincent Magaman to the National Assembly. Mr. Magaman has the suitable experience of being a councillor, a board member, of a state entity and being a member of the Gauteng legislature and currently part of the Johannesburg Development Agency, amongst others, currently responsibilities. The recommended member has went through the security vetting process to ascertain the eligibility. We are confident that the recommended member can add value in the work of the PSC. We are currently going through a far-reaching process of the professionalization of the public service. We should transform the public service and deepen a single public service. A single public service is critical in leveraging the totality of public service capabilities to work in integrated manner and to enable a movement of public servants to provide support to various levels of government without hindrance. Our public service is confronted with various challenges and is also undertaking transformative programs such as the increase of e-government capacity. And e-government will increase the efficiency of government in processing various services, and we believe this will contribute to addressing red tape in the public service and administration. The agility of the state is a critical area the Public Service Commission should contribute to enhancing. For a capable developmental state to thrive, we need to ensure that all public servants have the requisite skills and qualifications, strengthening the recruitment processes and ensuring there is compliance with existing policies is an aspect which determines whether the public service has public servants who are fit for purpose. We need to ensure we standardize the criteria of public service adverts and standards to avoid the reduction of standards on posts with the same functions. In the public service, constitutionally prescribed values and principles are a critical aspect. The Public Service Commission should protect and ensure the public service upholds, and where such is not complied with, the Commission should recommend it by reaching interventions. As the African National Congress, we will continue to support the work done by the institutions that have a critical role in strengthening and supporting our constitutional democracy. We are confident that the Commission is well constituted and to ensure our public service brings about social transformation and the socio-economic impact to address poverty, unemployment, and inequality. The ANC supports this report. Thank you, House Chairperson.
Thank you, Honorable Member. Honorable members, before I put the question, I want to recognize the Honorable House Whip.
Thank you, Honorable Chairperson. Can I make a request that we delay the taking of this decision of the question now until later in the afternoon before the rise show?
Honorable members, we'll get back to the question. The question will be put later in the sitting. It's in line with the rules. Yes, Honorable Member.
Please, could you cite the rule in which we're not taking this decision, House Chair, because we are wanting to take the decision now.
The question will be taken during the sitting. That's why I consulted with the NA table now, and they are going to give me the exact rule. There is precedence also. It's not the first time that it will happen, that we do not put the question immediately. It's a discretion of the presiding officer in terms of the question being put or not. I refer to you to Rule 99, and I quote, "When the debate on a question has been concluded in the House, the presiding officer may postpone the decision of the question I thus postpone the decision of the question until later this afternoon. The secretary will read the second order. Yes, honorable member.
House Chair, my understanding is that this vote can take place if there's 201 members in the House. I want to understand whether or not how many members there are in the House.
Honorable member, I have not put the question. There's no need to check a quorum. No decision will be taken until later this afternoon. The secretary will read the second order.
Debate on commemoration of 100 years anniversary on admission of women into legal profession.
I now recognize the Honorable Deputy Minister of Justice and Correctional Services, responsible for justice and constitutional development. The Honorable
Thank
Deputy
you,
Minister.
House Chairperson. Honorable members, I'd like to acknowledge the presence of representatives of the South African Women Lawyers Association in the gallery at the back. As we commemorate the centenary of women's admission to the legal profession, we pay tribute to the many women who have pioneered and championed the way for other women attorneys and advocates. We honor and pay tribute to those like Sonia Schlesson, Madeleine Wookey, Irene Geffen, Constant Hall, Gladys Steyn, Sissy Gould, Desiree Finkler, Victoria Mxenge, Lucy Mayulula, Leonora van der Heever, Yvonne Machoro, Cato Reagan, and so many others. Women in the legal profession have faced a long and ongoing struggle. The first woman who tried to be admitted as an attorney was Sonia Schlesson, who did her articles with Mahatma Gandhi. In Schlesson versus Incorporated Law Society in 1909, the Transvaal Supreme Court held that the word attorney meant men. Not only was Ms. Schlesson's application unsuccessful, but she also had to pay the Law Society's costs. One of the newspapers reported at the time that, and I quote, an application was made before Mr. Justice Bristow in the High Court Pretoria on Friday afternoon on behalf of a young lady named Sonia Schlesson. Mr. Justice Bristow refused the application with costs and declined to depart from the universal practice which precluded the admission of ladies as attorneys. The article stated that the refusal was based on the premise that, and I quote, the articling of women is entirely without precedent in South Africa and was never contemplated by the law. 3 years later, in 1912, the Appellate Division also refused Madeleine Wookey's application to be admitted as an attorney. A full bench of the division relied on Roman Dutch law and its exclusion from legal practice of persons who could be termed, quote, unfit and improper, including the deaf, the blind, pagans, Jews, persons who denounce the Christian Trinity, and women. Solomon J.A. in 1912 was compelled by, quote, the immemorial practice of centuries to conclude that women could not be admitted to practice as attorneys. A leading Cape judge of the time, Judge R.P.B. Davis, seemed to share these sentiments when he said, and I quote, the law of nature destines and qualifies the female sex for the bearing and nurturing of children of our race and for the custody of the world. All lifelong callings of women inconsistent with these radical and sacred duties of their sex, as is the profession of law, are departures from the order of nature and when voluntary treason against it. In the 1918 South African Law Journal, the then former Chief Justice of the Orange Free State, Melius de Villiers, wrote that, and I quote, it's absolutely most undesirable that women should be allowed to become practicing members of the legal profession. He argued that women being allowed to practice was a revolt against nature and incompatible with the ideas and duty of motherhood. Fortunately, 5 years later, in 1923, a law which allowed women to be legal practitioners was gazetted. The Gazette stated that His Royal Highness, the Governor General, has been pleased to assent to the Women Legal Practitioners Act 7 of 1923, which provided in Section 1 that women shall be entitled to be admitted to practice and to be enrolled as advocates, attorneys, notaries, public or conveyancers, subject to the same terms and conditions as apply to men. That is the law whose centenary we are celebrating. The historical anecdotes I've given are their testimony to the conservatism of the legal profession and the judiciary in the early 20th century. This is the law in which in 1923 paved the way for Irene Geffen, Bertha Solomon, and Gladys Stain to be admitted as advocates. 3 years later, Constance Mary Hill became the first woman to be admitted as an attorney in South Africa. In 1962, Sissy Gould was admitted as an advocate at the Cape Bar. And in 1967, Desiree Finkel was admitted as the first African woman attorney in the country after completing her articles of clerkship under Godfrey Pitje. Appearing before a magistrate in Vereeniging, Finkel struggled to be heard as the magistrate claimed he'd never heard of a Black woman attorney. It was only after he confirmed her status with another attorney that the magistrate apologized and continued with the proceedings. The first woman judge, Leonora van der Heever, was appointed to the bench in 1969 and was at the dawn of democracy in 1994 still the only woman judge. Later in 1994, Jeanette Traverso became our country's second female judge and Lucy Mailula the first African woman judge. Later that year, Cato Reagan and Yvonne Mokgoro were appointed to the Constitutional Court. Although women have been practicing law for 100 years, we still have a very long way to go before we can truly say that there's gender equality in the legal profession. According to the Law Society of South Africa, in 2022, there were 29,981 practicing attorneys in South Africa. And of these, 12,714 are women. It would be appreciated, Honorable Mazzoni, if you could keep quiet. It's difficult to concentrate. This means only, maybe you're not interested in the
Order, honorable
maybe
members,
you're not
honorable,
interested in the topic.
honorable
but you
deputy
should-
minister, order, order. Honorable members, let us give the speaker an opportunity.
This means that only 42% of the profession of women, despite the fact that according to Stats South Africa's midterm population estimates, 51.1% of our population are women or female. What is encouraging, though, is that when one looks at the number of candidate attorneys, more than half are women. Of a total of 6,445 candidate attorneys in our country, 59% are women. When one looks at the advocates, according to the 2022 figures of the General Council of the Bar, there are 2,990 advocates at the various bars or advocate societies falling within the GCB. Of these, 953 are women, and this equates to 31%. Of these advocates, there are a total of 555 silks or senior counsel. Of these, only 61 are women. That's 10.9%. But it's not purely a numbers game either. We need to look at where and at what level of an attorney's firm the women practitioners find themselves. My office had a look at 2 of the so-called Big 5 law firms in South Africa and counted the number of women in positions such as partner, director, head, or co-head or executive in these firms. At one firm, there were approximately 118 senior legal practitioners, of which 70 were men and 48 were women, which is 40%. At the other firm, there were 186 executives and or directors, of which 118 were men and 68 were women, which is 36.5%. Chairperson, the legal profession is clearly still a male-dominated profession, and thus more should be done to make it not only attractive to women, but more importantly, also to retain them. The issue of women lawyers exiting the legal profession has been the subject of many studies, research, and articles. A 2019 report by the American Bar Association used empirical data to look at the reasons why so many experienced women lawyers were leaving their firms. And the report concluded with concrete recommendations for law firms to help keep women lawyers, including developing a strategy, setting targets, and establishing a timeline for what the firm wants to achieve, taking steps to ensure there's a critical mass of female partners, assessing the impact of firm policies and practices on female lawyers, and providing resources to relieve pressures from family obligations that women more often face than their male colleagues. Here in South Africa, I think these are some of the types of conversations that we should be having with and within the legal profession. At the recent ceremonial sitting held in the local division of the High Court in Johannesburg to commemorate the centenary, Advocate Khomotso Morocco SC spoke about how she completed her law studies and was required to do her articles of clerkship. She spoke about how no law firm would hire her except for one that gave her the opportunity, but first she had to take an IQ test. She further spoke about when she joined the Joburg Bar in 1989, she was only the second Black woman advocate at the bar. More importantly, she pointed out it was a struggle in the sense that she had 3 children at the time and had to balance work and home life. Advocate Morocco added that there was a point she had to bring her 5-year-old child with her to work. Personally, I think we can and should do more to allow for more flexibility for women in working conditions for women practicing law. We must remove the glass ceiling. We very often measure legal experience in specific years, but what about a woman who decides to take a year or 2 away from the legal profession? That break shouldn't count against her when it comes to career advancement or her suitability for the bench. It's also about the type of work and the briefs women are given and exposed to. And that is why from the side of the Department of Justice and the state attorneys, we've made a specific target that we give a certain percentage of our legal briefs to women legal practitioners. We want to ensure that at least 40% of briefs be allocated to women, with a target increasing year on year. We also want to ensure that from this financial year, at least 30% of the value of briefs be allocated to women. The reason for an indicator on value is to ensure that women are not given the cheaper, less complicated briefs. I'm also pleased to be able to share with you that at the end of last year, 52% of our magistrates are women. Many of these women magistrates will no doubt soon be on the bench in our high courts. I want to commend and highlight women attorneys like Ms. Mabayeng Lenyai, who was recently appointed as a judge to the Gauteng Division of the High Court. As an attorney, Ms. Lenyai was the first woman president of the Law Society of South Africa and therefore sits on the BRICS Legal Forum Council and the Council of the International Bar Association. When women legal practitioners make themselves available to the bench, they enrich and strengthen our courts and our entire justice system. The South African Judicial Education Institute, therefore, also has an aspirant women judges program, and I want to encourage everyone to identify and encourage women to apply. Our courts need them. The Chief Justice has named the program in honor of the first woman Minister of Justice in South Africa, Bridget Mabandla, as she had done much to promote the advancement of women in the legal profession. Honorable members, from our history as a country, we know that women played a pivotal role in the attainment of our freedom. They did the same in our legal profession. I therefore want to celebrate every woman lawyer in our country, those who paved the way for others, the women law students who overcome the odds to follow their dreams, the women candidate attorneys and pupils who go on to become attorneys and advocates and later partners or senior counsel, and our women magistrates and judges. We can once again proudly say, Malibongwe. I thank you.
The next speaker is the Honorable Van Minnen.
Thank you very much, House Chair. I must say, as we stand here today talking about 100 years of women in law, we have just seen the most perfect example of mansplaining, with a man telling a woman to keep quiet. Now, the first woman seeking to be admitted as an attorney in 1909 was indeed Sonia Schleisen, who'd been articled to Mahatma Gandhi. Although she worked very closely with him and was very instrumental in the early development of his movement, she was turned away by the High Court in Pretoria as women were deemed to be unsuitable for the practice of law, which I think is a narrative that we're still hearing today. Presumably, hoping for a more liberal justice in the Cape Supreme Court, Madeline Wookey in 1912 sought to compel the Incorporated Law Society to register her articles of clerkship as an attorney and a notary. She was right when Marsdorp JP, a forefather of mine, came to the conclusion that women were equally entitled with men to be enrolled as attorneys on given proof of the necessary qualifications. Unfortunately, she ran into a brick wall and she failed in front of the full bench, and it was only in April 1923 that women were first admitted, with Irene Geffen being admitted as an advocate in 1923, which was a full 10 years before white women were able to exercise their vote in the 1933 election, electing the first female MP being Lily Rates. We then saw Constance Hall admitted as an attorney in 1926. Only in 1962 was Sissy Gould, who was a particularly extraordinary woman, admitted as an advocate at the Cape Bar. She was also the first colored woman to receive a master's degree from the University of Cape Town, serve on the UCT Council, and for several years was the only woman and the first woman of color serving on the City Council. 3 years later, in 1967, Desiree Finca Mutata became the first Black African female to be admitted as an attorney. Women now make up at least half, if not the majority, of law graduates, but comprise only 42% of attorneys and 30% of advocates. Indeed, even the statistics don't tell the true story, as there's a huge disparity for the areas of law where you will find most women. Women tend to find their practices in the so-called softer areas of law, although whether they're softer at all is very debatable, being family law and conveyancing, while fields that are seen as more prestigious, such as criminal law, corporate and tax law, remain very much the preserve of men. In my family, my grandmother's younger sister, born in 1906, qualified as a lawyer in the late 1920s. My cousin's wife was Mavis Gumedi, a Zimbabwean, one of the first Black barristers in England in the early 1970s. She later became a judge in Zimbabwe and then in Namibia. And in fact, when she retired, was the longest serving justice of the High Court. But in my graduating class, very few women are still practicing. A quick call around yesterday would indicate that of my university graduation class, probably only about 5 are still practicing. I spoke to one of them yesterday, one who serves in the field of constitutional law. You would think that she was very much somebody who had achieved in a difficult field. And I apologize, House Chair, for quoting her directly when she simply said to me, but we all know that law is cuck. Now that's a huge problem. So where are the women? Why do we see the phenomenon of vanishing women legal professionals? It's deeply ironic that law is personified by Lady Justice, whose statue stands outside the courts in many countries. And yet women's representation in the legal profession is an ongoing issue. At the most productive stage of their careers, women often decide, or are forced, to leave the industry for various reasons. Key to this, long hours, unpredictable schedules, pay disparities, the drive towards maximizing billable hours, the hyper-competitive environments that erode collegiality, and hostility towards a reasonable life-work balance. There are many instances of burnout, stress, exhaustion, and levels of job satisfaction are generally low in an environment that is rife with sexual discrimination, not just crude sexual harassment, but ongoing and insidious sexism. This is particularly seen in the area of who gets briefed and who gets advanced in the profession. As we heard from the previous speaker, the majority of the people who are briefed with state work are men. What is needed is a deep societal shift and a definitive drive to make the profession such as law more open to the diversity that is present in society. Not just a recognition of legislative equality, but drives towards substantive equality, a marked move away from gender stereotyping that create the silk ceiling, and a recognition of the value and ability that women bring to law. And this can only happen in a society that is more open to equal opportunity, freedom, genuine fairness, and diversity. A society where all people are valued for what they bring to the table, and where opportunities are created for people to take them up based on their own merit and ability, and not on some stereotypical category based on box-ticking characteristics. And only at that point can we argue that women are indeed welcome and can thrive.
Remember, your time has now expired. Honorable members, I just want to caution members on the use of language at the podium. A point of order was not taken. However, it does not justify the use of that word that was used at the podium. It's unacceptable. The EFF
Thank you so much, Chairperson. Chairperson, South Africa possesses a lengthy history of women who have significantly contributed to the various struggles in our country that it has faced. Women in South Africa have endured more hardship than any other demographic. In particular, Black women have often been relegated to the background in the prioritization of human rights, frequently used for slogans and displays of progress, while still continuing to grapple with the many struggles. Today, we commemorate a centenary since the admission of women into the legal profession. How much more remarkable this commemoration would have been had we seen a woman occupying the Chief Justice in South Africa, as it should have been. The decision by our president to choose Barry White over a recommended appointment by Judge Maya by the JC signals an entrenched disregard for Black women in the legal profession. That is true, and you know it. It suggests an absence of desire to portray Black women in a positive light. It illustrates a lack of commitment from our government to advance towards a restoration for Black women. Chairperson, Judge Maya represents an unblemished, incorruptible, a dignified character, a person who's deeply knowledgeable and understands South African law, having proven her worth as a legal expert. It is both astounding and yet sadly unsurprising that this government has failed to recognize her due to her political interference. Regrettably, women are still perceived but not truly heard, regardless of the significant work that they have been promoting within the profession. Moreover, the continued persecution of Advocate Mkhwebane using state resources should induce a sense of discomfort in this parliament. Black female lawyers make up to 20% of the workforce in law, indicating a significant underrepresentation they face in the sector. Even those who have managed to enter the profession are finding it difficult to thrive. Black female LLB graduates are struggling to secure articles and even privileges. You know, some Black lawyers are still not taking their maternity leave as we speak, because they understand when you take maternity leave, you're seen as not being productive. You're seen as not contributing to the status quo. You're seen as being lazy. And in fact, in 2023, we should not be facing such instances. That is because most Black female lawyers are absorbed into the private sector, and the private sector views them as such. So we should actually look at ourselves as government in South Africa and see how we view Black lawyers and how we assimilate them into our structures and make sure that we give them capacity enough to understand the work that they do and understand how valuable they are in this country. Most Black lawyers in this country are sexually exploited by Black senior advocates, by Black senior judges, by Black senior magistrates in this country in 2023, and that is a fact. The state, it seems, is mainly paying lip service to the empowerment of Black legal practitioners, which is an even greater issue for women. Chairperson, Black lawyers are still grossly underrepresented, and the government rarely briefs Black lawyer firms, especially those run by Black women. We frequently hear about cases of women in the legal profession who become victimized while trying to establish a foothold. In a country with progressive laws and policies, such as the recently passed 3 GBV bills, one would presume that women in law would be instrumental in overseeing these courts. However, this is not the case. In a country grappling with severe social dysfunction, crime, and laws directed against women, should not the legal profession strive to place women at the forefront of restoring these issues? Should we not be the ones who are judging these cases? Should we not be the ones overseeing these cases? Should we not be the ones making sure that the perpetrators are seen to book? It is disheartening, however, to see the number of Black women who have qualified as advocates, as lawyers, as judges, as magistrates, and more. We would like to assure them that their work does not go unnoticed. But in 2023, should we still be battling for the rights that should be inherently granted to us? Chairperson, we acknowledge trailblazers such as Desiree Pfingwa, the first Black attorney to be admitted. Their work has not been in vain. There are numerous challenges confronting Black female lawyers in our country, and these must be prioritized if we want to establish a capable and fair justice system in South Africa. Women should never be viewed as proxies or political pawns in high-profile cases. It must be a fundamental principle to place women at the center of our legal processes and have confidence in their capacity to maintain that center. Chairperson, as we mark the 100-year milestone of women's admission into the legal profession, it is imperative to not only celebrate this achievement, but also to reflect on the issues that persist. The underrepresentation.
The Honorable Mashiko, it has now become a habit that every time when we have a virtual hybrid sitting, you interrupt proceedings. Please switch off your microphone. And may I ask the ANC whips to attend to this matter outside of the meeting, please. You may continue.
Thank you, Chairperson. Chairperson, as we mark the 100-year milestone of women's admission into legal profession, it is imperative to not only celebrate, but also to reflect on the issues that persist. The underrepresentation of women in law, they struggle to regain recognition and respect, the government's apparent lack of commitment to their empowerment. These are not issues we can afford to ignore. Today, we call for inclusivity, supportive and equitable legal profession, one that truly reflects the direction of our nation. It is time to transition from mere words to concrete actions that enable the advancement of Black women.
Remember, your time is expired.
Chair, I have 18 seconds.
No, no, honorable member. Your time is expired. Your time is expired.
Thank you, Chairperson.
The next speaker is the Honorable Majosi.
Thank you, Honorable House Chairperson. Although sidelined and excluded since time immemorial, women have always found ways to contribute to the struggle for freedom in this country. They have made immeasurable sacrifices while being subjected to the dehumanizing force of ridicule, sidelining, mocking, and exclusion, which was all based on their gender. It is due to this exclusion that although laws were passed to allow men to stand before competent courts of law as advocates, attorneys, and overall legal practitioners, women were denied this very same access, although possessing the same skills, intelligence, hard work, and all other qualities that make a successful legal practitioner. Chairperson, our focus today is on the development brought about by the Women Legal Practice Act 7 of 1923. It is through this act that we saw the first woman, Irene Geffen, being admitted as an advocate the very same year. 3 years later, Constance Mary Hall followed in her footsteps and got admitted as the first female attorney. Sadly, due to heightened apartheid law and regulations, Black women were still not allowed admission as legal practitioners, at least not until 44 years after the passing of the act. It was Desiree Finger who paved the way by becoming the first Black female South African law in 1967 after her admission as an attorney. With a population of more than 59 million people, statistics released in 2022 revealed that there were only 12,714 practicing women attorneys in this country, making up only 42% of the role of practicing attorneys. Of the 3,083 advocates in this country, only 28% were women, and out of these, only 338 were African women. Why are these figures so stringently low when more than 100 years have passed since women have been permitted to practice as legal practitioners? This is due to the fact that there are barriers which are still deeply entrenched in our society that stand in the way of women thriving in the legal profession. For example, women are still victims of gender bias, both personally and professionally. Since 2016, there has been a 7% increase in fully women-owned firms. And although this is a step in the right direction, we ought to acknowledge that barriers such as financial access, or rather the lack thereof, still exist and stand in the way of the attainment of admission in the legal profession for most women. Even though on paper, women are presented with the same legal opportunities as their male counterpart, it is an open secret that women tend to receive smaller in terms of the volume of and quality legal briefs, which further perpetuates gender discrimination. Although honest reflections such as these may dampen our mood and cast a shadow of doubt amongst us, it is perhaps very important to bring to light exceptional women such as Justice Mahube, Betty Mulemule, who was recently appointed as President of the Supreme Court of Appeal, and Advocate Sinako Lindazwe, who, together with others, continue to dedicate their talents, lives, and resources to nurturing the next generation of women lawyers in general and Black women lawyers in particular. Although today we celebrate 100 years of women in the legal profession, we ought to be honest that there has been a slow rise in the number of women legal practitioners in the country. And we encourage the government to create an environment that cultivates the talents of many young women throughout the country who wish to one day positively contribute towards the growth of the profession in one way or the other. We must deal with patriarchal system. Ngiyabonga Sihlalo.
Thank you. The Honorable Jana.
Thank you, House Chair. Honorable House Chair, we've come a long way, not only as women, but as a country and as a society. We've come from a place where it was once unclear if a woman can be included in the definition of a person in order to be registered to do her articles and ultimately be admitted as an attorney, to where we're celebrating 100 years of women in the legal profession this year, where we as women, who once were considered second-class citizens, some of us even having been considered perpetual minors, are able to stand up and be counted in the courts of law, the boardrooms, and the legislatures of this country. We follow in the footsteps of women such as Irene Geffen, who was the first female advocate admitted in South Africa in 1923, Constance Mary Hall, the first female attorney admitted in 1926, and Desiree Finca, who was the first Black female attorney to be admitted in this country in 1967. These women broke down barriers and triumphed over seemingly insurmountable stumbling blocks to pave the way for us, our sisters, and our daughters in the legal profession. Ons dank hulle, ons eer hulle en ons bou daagliks op hulle harde en moeilike werk voort. Maar agbare voorsitter, die stryd is egter nog lank nie gewonne nie. We've come from a place where women were nothing to where women make up nearly 50% of practicing attorneys in the country, where women sit on the bench and where a woman is even the president of the Supreme Court of Appeal. Yes, there are fee and brief disparities. Yes, discrimination, barriers and stumbling blocks such as sexual harassment and the ever-present boys' club establishment hamper equal participation in the legal profession. Women mainly being primary childcare providers is a factor that must be accounted for. We have to contend with female stereotypes on a daily basis, such as the perception that women are more emotional and more sensitive than men, and therefore are not tough enough to do this kind of work, and that we're only there to take notes or pour tea. And any woman in the legal profession, myself included, can confirm this. But we've triumphed over worse, Honourable House Chair. We are breaking down those stereotypes and barriers, come hell or high water, on a daily basis. And let me tell you, some of the best legal practitioners I know are women. Women such as Justice Betty Molamela, and even closer to home, our colleague Honourable Breitenbach. Sadly, Honourable Chair, history tends to repeat itself, because for every step we as a society take forward, the ANC now takes us 2 steps back. 100 years ago, the judiciary did not only discriminate against women, it also legitimized the racial political order of the day, much as the government is doing now. We as a society has literally pulled ourselves up by our bootstraps to break the ties of gender and racial discrimination, to strive and work toward an equal society where one day equal opportunities will lead to merit-based outcomes. Yet the ANC insists on taking us back to a place where the color of all South African skin, like a pencil test, will determine our success in the workplace. You're taking us back to a place like 100 years ago, where discrimination is law, where people are not seen as people, but as a number, a percentage, as nothing more than a quota. The Women Legal Practitioners Act from 1923 succinctly states that women shall be entitled to be admitted to practice and to be enrolled as advocates, attorneys, notaries public, or conveyancers, subject to the same terms and conditions as apply to men. And any law in force regulating the admission or enrollment of persons as advocates, attorneys, notaries public, or conveyancers shall henceforth be interpreted accordingly. If an act from 1923 can get equality right, why can't the ANC government? House Chair, I thank you.
Thank you very much, Honorable Jana. The Honorable Swart.
Thank you, House Chair. House Chair, the ACDP welcomes this debate commemorating 100 years of women being admitted into the legal profession. And we too honor those brave women who pioneered admission, as pointed out by earlier speakers, resulting in the Women Legal Practitioners Act of 1923. And although the percentage of female legal practitioners has increased dramatically compared to pre-1994 numbers, many, sadly, still do not have the same access to opportunities as their male counterparts. It is disgraceful that female law professionals should be regarded in any way as less competent or not suited for certain types of law, purely on account of their gender. And in addition, women of color often face the additional discrimination by virtue of their race, this alongside that of their gender. This is wrong. It is regrettable also that following many years of discrimination, female advocates are not receiving sufficient briefs from attorneys. In addition, female legal practitioners have stated that they face sexual harassment in the workplace. The Constitutional Court has made it very clear that sexual harassment is the most heinous misconduct that plagues the workplace. And although prohibited under labor laws of the country, the court said it persists. Not only is it demeaning to the victim, but it undermines their dignity, integrity, self-worth, striking at the very root of a person's being. The ACDP agrees and welcomes the Legal Practice Council's sexual harassment policy. We trust, however, that it is being properly implemented. Sadly and understandably, complainants often want to remain anonymous, which makes it difficult to investigate these matters. We call on all in the legal fraternity, and indeed in all sectors of society, to stand against sexual harassment in the workplace. It must not be tolerated. There are many notable achievements of women in the judiciary, such as the appointments of Justice Molamela as President of the Supreme Court of Appeal and Deputy Chief Justice Meyer at the Constitutional Court. Justice Meyer says the presence of women in the judiciary elsewhere profoundly impacts the imperatives of a diverse society. Their participation creates a public decision-making entity that is aware of and sensitive to different positions, experiences, and needs of many individuals representing various socioeconomic backgrounds in our communities. The contribution of women jurists make to the country's jurisprudence is distinctive and unquestionably exceptional. The ACDP agrees. Thus, while we can commemorate 100 years of admission of women into the legal profession, much still needs to be done to remove those many barriers that still exist in preventing women from fulfilling their full potential. I thank you.
Thank you very much, Honorable Swart. UDM, ATM, the Honorable Heron.
Thank you, House Chair. House Chair, portraying justice as a female figure dates back to the depictions of Themis and Justitia in ancient mythology. Themis, known for clear-sightedness, was the Greek goddess of justice and law. In Roman mythology, Justitia was one of the four virtues, along with prudence, fortitude, and temperance. And in ancient Egypt, the symbol of justice was a woman too. Yet the systems of justice that much of humanity has developed over the intervening several thousand years has largely excluded women. In a country like South Africa, where structural patriarchy evolved over centuries to drive disrespect for women and gender-based violence, it doesn't help that our jurisprudence has to a very large degree been developed by men. As a lawyer, I am grateful to all of the exceptional women lawyers who helped form the lawyer and the politician that I am today. I've been blessed and privileged, and I'm grateful that in my journey to becoming a lawyer, I've been taught by and practiced with the most inspiring women. And I would like to take this opportunity to acknowledge one of those women, Dr. Navi Pillay, a woman and a lawyer who had a massive impact on my life and the path that followed to where I get to stand here today. When she was a lecturer at the University of Natal when I was studying there. Dr. Pillay taught a course called Race Legislation, a deep dive into the repugnant, oppressive, and criminal laws that propped up the apartheid regime and denied people of color their rights, their humanity, their dignity, and their economic development. And while we are celebrating 100 years since women were allowed to enter the legal practice, we would be remiss in not drawing attention to the fact that in 1923, when the act was promulgated, Black women were still excluded due to discriminatory apartheid policies, and that it would take another 44 years for the first Black woman to enter the legal profession in 1967. Dr. Pillay was one of those women. In 1967, Dr. Pillay became the first Black woman to open her own law practice in the then Natal province. She said she had no alternative. In fact, she said, no law firm will employ me because they said they could not have white employees taking instructions from a colored person. And we commemorate the progress we've made and that have been made by women and of course, Black women in the legal profession. We have to recognize the historic barriers that they overcame and that were part of the racial and gender disadvantages that have created the racial and gender inequalities that persist today. And it is in this context that it is offensive when uneducated, privileged white men, some who get to lead political parties, weaponize redress legislation like employment equity, as if the barriers of racism and patriarchy are no longer alive today. Thank you.
Thank you very much, Honorable Aaron. The Honorable Sheikh, Imam.
Thank you, Honorable House Chair. Allow me to start off by extending our condolences to the family, friends, and the ANC on the loss of a stalwart, a great woman, chairperson of the Portfolio Committee, someone that we had the opportunity of spending a few days with 2 weeks ago in Kimberley and Pretoria. In fact, we awoke to some devastating news yesterday. May her soul rest in peace. Now, Chairperson, there is no doubt about it that we have made strides, successful strides, in dealing with the discrimination that our women faced many, many years ago. And whilst our women faced discrimination because they were women, today they continue to face discrimination because of the patriarchal society that we live in. And I know many of us will come here today and tell you how much we love our women, how much we respect them, how we acknowledge them. But let's go back to their homes and see if that is the case. Clearly, it is not. You know, that is why I always say, in this case, you can be a judge, you can be a magistrate, you can be a lawyer, you can be a prosecutor, you can also be a mother, you can also be a father. That is a woman. You can't find a man that can be a mother, a father, a lawyer, a magistrate, and a judge. It's the reason why I say that if you have everything in the world and you don't have a mother, you have nothing. But if you have nothing in the world and you have a mother, you have everything. Now, some of the statistics that we have, and I'll give you one good example, of the 1 billion rand that was allocated to the legal profession, only 301 million rand was paid to women. Now, what is also common, particularly with government departments, we find, they tend to give more work to male-dominated legal firms than female, legal firms. And I think it's something that we must address. The other problem that we seem to be experiencing, and it's in the public domain all the time, Deputy Minister, I'm sure you're coming across this, is sexual harassment, sex for favors for jobs, not because the women are capable and have the capacity and the integrity, because we regard them as sex objects and they must pay for it. That must change. I think it must change. Lastly, I want to end by saying we support the transformation of the judiciary and the entire system, promoting women. And let me leave you with this, that a little child was
Thank you very
yesterday
much.
massacred in Palestine. Thank you very much.
Thank you very much. AIC.
Thank you, Chair. On the 10th April 1923, the first installment of women advocacy and legal recognition to practice as advocates and attorneys was promulgated into law. The Women Legal Practitioners Act of 1923 ushered a new paradigm shift in human history. Its post-amble decreed that, I quote, women shall be entitled to practice as advocates, attorneys, notaries, public or conveyancers, subject to the same terms and conditions as applied to men, close quote. It was no surprise that in 1967, 44 years after the promulgation of the said act, the first Black woman was admitted as an attorney. 44 years is not a long time if one considers the far-reaching implications of 1948 installation of the apartheid rule. The dual sins of racism and gender inequality meant Desiree Finger could only be enrolled as an attorney only in 1967. Surprisingly, the quest for gender equality in the legal profession is still a thorny issue 100 years after the installation of the Women Legal Practitioners Act. While we celebrate the likes of Desiree Finger, Sister Kampembe, Yvonne Makoro, Benz Gabinde, and many other outstanding women jurists, there are stubborn challenges confronting women in the legal profession. Honorable Chair, the Johannesburg Bar has only 9 women of color, and there is a recurring theme of lack of equitable briefing between women and men advocates. Male advocates are still preferred over their female counterparts in handling higher profile cases. It is often ignored that it is women who have produced such well-meaning jurisprudence in our country. The following are the facts. A former head of state in our country was sentenced to jail by a woman judge. The name is Sister Kambembe. Members of the South African National Defence Force Union were told in a clear terms by a woman judge that their service was an essential service and that they could not engage in any industrial action. Judge Masipe recently co-authored a report with Justice Ngobo in which the current president was found to be on the wrong side of the law in the Phala matter. It was Justice Mohoro who found Nomgabo Jiba and Lawrence Mhwebi to be unfit to hold office in the NPA. It was Advocate Tulima Donzala who reigned executive power and told a former president to pay back the money.
Thank you very much, Honorable Member.
Thank you, Chair.
The Honorable Masego Chele.
Honorable Chairperson, members of the House, fellow South Africans. Chair, as we celebrate 100 years of women in legal profession, the African National Congress, before that, we wish to convey our heartfelt condolences to the family, friends, and colleagues of our beloved Honorable Ma'am Tina Monica Jomet Peterson. Mam Tina was a seasoned political and lawmaker who rose in the ranks of the ANC. She dedicated her life to the service of our country from a young age, and her contribution, Chair, will be remembered by all of us, particularly women in this country. Even as we commemorate 100 years of women in the legal profession, her valuable input in this debate is recorded. May her soul rest in eternal peace, and may she rise in glory. Chairperson, the apartheid era fraught with patriarchal and racist ideology left a mad society rife with gender and racial inequalities. It is well documented that at the commencement of the new constitutional democracy in 1994, the bench comprised of 165 judges, of which 160 were white men, 3 black men, 2 white women, and no black women. Racial and gender discrimination were deliberately used to oppress women and keep them away from a profession previously reserved for men. As has been alluded to, women were not considered to be persons enough to practice law. Legal means were used to advance patriarchy and oppression. The 1912 Appellate Division case, which barred women from practicing law, Law Society versus Buhuki, was followed by some obnoxious outpouring in the South African Law Journal, quoting as US judgment. The article read, I open quote, "The law of nature destines and qualifies the female sex for the bearing and nurture of the children of our race and for the custody of the world and their maintenance in love and honor and all lifelong calling of women, inconsistent with these racial and sacred duties of their sex, as is the profession of law, are departures from the order of nature and were voluntarily treason against it," close quote. Chairperson, the level of prejudice meted against women have been unpalatable, to say the least. This was carried out with the blessing of the colonial era judiciary. As we know, injustice should never be embraced but fought. Women were never going to stomach discrimination forever. With our democracy dispensation, strong institutions have been created and led by legal trained women. For example, Mam Togo Majokweni, a former magistrate and then a senior state advocate, was appointed as Deputy Director of Public Prosecutions in 1996, as the first African woman to be appointed in that position. She was then appointed by the President as the first woman Special Director of Public Prosecutions in the Office of the National Director of Public Prosecutions. She was specifically tasked to set up and head a unit that would specialize in dealing with gender-based violence, sexual and other offenses, known as Sexual Offenses and Community Affairs, SOCA unit, in short. She and other women were at the forefront of setting up sexual offenses court, the institutionalization of prosecutor-led investigations in cases of gender-based violence and violence against children, as well as the coordination of services for an efficient and responsive criminal justice system. The SOCA unit developed and introduced the Tutuzela Care Center model as an integrated multidisciplinary model, which is victim-centered with prosecutor-guided investigations, is co-directed and involves stakeholder cooperation. To date, we have TCCs across the country, and through them, secondary trauma to victims of sexual offenses has also been reduced significantly. A century has passed, Chairperson, and yet there are still barriers which hinder women's progress in the legal profession. The slow pace of gender transformation of the judiciary cannot be examined and in turn rectified in isolation. Research indicates that the number females graduating and being admitted as attorneys is slightly higher than that of males. The deepening disparity starts to become increasingly visible when examining the gender disaggregated statistics of practicing attorneys or advocates. It can be concluded that there are no substantial barriers in university admission and qualifying as an attorney or advocate, but focus should be therefore be at the legal practice level within the legal landscape. There are still underlying and widespread discriminatory perceptions of women's competences as legal practitioners being as substantially weak than their male counterparts, which is a myth, Chair, that has to be dealt with contempt it deserves. There is general perception from other practitioners that women lawyers are only good in certain areas of law and are not good in complex litigation matters. This general perception leads to women lawyers not getting their experience and exposure in lucrative areas of law, both from the private and the public sector. Further, this compounded by the rigidity of the profession wherein excessive work hours are expected. Socially accepted gender roles within society equate to social and family responsibility falling largely upon women practitioners. The legal landscape is very patriarchal in its formation and does not cater for the different roles that women lawyers should fulfill at various stages in their lives. For example, motherhood is perceived as a career limiting. Women find themselves having to choose between mothers and being legally practitioners. Issues of sexual harassment in the workplace of junior women legal practitioners, as indicated before, and by honorables, and indicate attorneys are not being dealt with openly and transparently. And there is a fear of victimization for those who report incidents of sexual harassment. Such incidents discourage young women from remaining in the legal profession. Another challenge picked up is that of mentorship of women lawyers, which is taken up by other women in the legal profession, as most males demonstrate a reluctance in mentoring young black women practitioners. Failing to consider women in academia or private sector in judicial appointments limit the entry of women in the profession. There is significant pool of potential women judges in academia, in private and public law that can greatly help to increase numbers. Academics are well trained in content of the law. It may be argued that some might lack some practical experience, but this is easily rectified by seeking out women academics to serve as acting judges. The issue of briefing patterns, Chair, is also very important in terms of the numbers and quality of briefings. We celebrate the women of this country and wish to see more and more women entering the profession. Malibongwe.
Thank you, Honorable Member. Hope. Thank you, Honorable Madisha. PAC. PAC. The Honorable Hendricks Aljama.
Thank you very much, Honorable Chair. Honorable Chair, I join other honorable members to express my sorrow and shock at the sudden death of Tina. Hours before her death, in a place called New Horizons, we were handing out sanitary pads that she donated or arranged for us to get by courier to hand out to these girls. And she was also very passionate about the water crisis and gave me some solutions for the city of Johannesburg. So we'd like to express our condolence and thanks for this opportunity. With regard to the 100th commemoration and admission of women into the legal profession, Honorable Chair, a lot of progress has been made in South Africa, and I refer to the appointment of Justice Mandisa Meyer as the country's first woman Deputy Chief Justice. I think we need to celebrate that. However, women are still being discriminated, and unfortunately, the Department of Justice is in the forefront of discrimination. They still don't give indigent women transport costs and to come to maintenance costs, but they give it to men. And I'm very grateful that the chair of the Portfolio Committee has stepped in to try and get the Department of Justice to stop their discriminatory practices against women. In fact, I want to suggest that when it comes to maintenance court matters, men must be banned and women must deal with, so we can fast track the rights of women as far as getting maintenance to put food on the table for the children that men need to fulfill. I was very interested in the history that the Honorable Heron gave, and my own constitution, the Muslim community, after the Prophet, women played a very important role as legal practitioners, and they acted as advocates to people who came to advice on the Sharia. And we hope now that that will inspire Muslim women to play an active role when it comes to an alternative dispute resolution structure to deal with Muslim marriages and divorces, keeping it out of the courts. Honorable House Chair, women have played a central role in today's the development of law in South Africa, and we need to make sure that they get briefs. Women need briefs, and attorneys must start the briefing women advocates and mentoring them. Thank you very much, Honorable House Chair.
Thank you very much, Honorable Member. The Honorable Ramolube. Oh, sorry. Sorry, Honorable Member. Sorry. Sorry, Honorable Buckley. Sorry about that.
Thank you, Chair. We celebrate 100 years of women in law, but we're hearing a lot of words from the ANC. How about the state briefing women for a change? How about cadres who get caught with their hands in the till briefing women for a change? It's about time. It was Tacitus in the 2nd century AD who said, the more corrupt the state, the more numerous the laws. Law is not going to go away. We're facing a corrupt state right now. Laws are essential to the running of every modern society. And in order to uphold the laws and manage them, it requires lawyers. If the laws could speak for themselves, they would complain about lawyers in the first place. That was Lord Halifax. We can be proud of our country in that we're far ahead of many other jurisdictions around the world. Our modern constitution protects the rights of all people equally. Our legal profession has long since been the forerunner of this concept. We must be proud in that the legal profession has for many years sought to protect rights of individuals throughout the ages. You will remember the Nationalist Party were forced to try and load the bench in the appellate division in order to protect the apartheid laws. Today, we can be proud that the legal profession stands outside politics and protects our law and our constitution with vigor. The fact that the legal profession stands outside politics and petty arguments is a shining light of our democracy. Our constitution, which is the supreme document of our society, very carefully protects the rights of individuals, which rights are properly and carefully handled by the legal profession. Today, it can be said that the legal profession is truly equal between men and women. However, it was George Bernard Shaw who said, "We learn from experience that men never learn from experience." We've still got a problem. In the Incorporated Law Society versus Wookie, which was an interesting case in 1912, the appellate division upheld an appeal brought by the Law Society against the decision by the Cape Provincial Division, declaring that a woman was entitled to enter into articles of clerkship as an attorney's clerk and to be rolled as an attorney upon obtaining the required qualifications. The appellate division held that the word persons in the Cape Charter of Justice included only male persons and that the respondent, Mrs. Wookie, was not entitled to be enrolled. Then the court referred with approval to a passage which stated, and I want to quote this, "Likewise, owing to the same natural peculiarity, it happens that, inasmuch as nearly the whole of womankind, by reason of an inborn weakness, is less suited for matters requiring knowledge and judgment than men, women are excluded from holding any office or dignity relating to the government of a people and its affairs." We can hang our head in shame because of that history. However, today it can be said that women in the legal profession have taken their rightful place in many cases. Women hold senior controlling positions as partner of law firms, leading lights at the bar. Our country has made great strides in ensuring that there's equal representation from women on the bench at all levels of our court. I was initially admitted to the bar in July 1982, that dates me somewhat, and thereafter the sidebar in 86. Throughout my career, and I'm still practicing today, women have been senior partners, and as a practicing attorney to this day, I'm proud to say.
Honorable Bergman. Honorable members, you will keep on persuading you to be very careful of your gadgets. It's disturbing a lot. Sorry about that, Honorable Bergman. Can you continue?
Proceed. We must understand that lawyers will always be with us. Even Shakespeare would shake at that. It was Samuel Goldwyn who said, "A verbal contract isn't worth the paper it's printed on." There's an old-time joke told by lawyers that 99% of the lawyers give the other 1% a bad name. The Democratic Alliance salutes our country's women lawyers, judges, and legal administrators, and we congratulate those in the profession. Thank you.
Thank you, Honorable Member. The Honorable Ramulobeng.
Thank you, House Chair. Honorable Chairperson, Honorable Chief Whip, members of this august House, compatriots, comrades, and friends. As we commemorate 100 years of women in the legal profession, it is important that we take a moment and reflect on the journey we have traversed. The legal profession is one of the world's oldest professions, and yet it was only 1923 through the Legal Practice Act that women could join the profession. As we know, prior to the act, women were not considered to be persons who could be admitted to legal practice. The 1923 Act opened the door for women by pronouncing that women shall be entitled to be admitted to practice and to be enrolled as advocates, attorneys, notaries, public or conveyors in any province of the Union, subject to the same terms and conditions that apply to men. A ceremonial court sitting was held on the 25th April 2023, and Gauteng Judge President Dustin Mlambo overturned two judgments which were issued in 1909 and 1912, which barred women from entering the profession. Judge President Mlambo declared that the two women in those cases had been admitted to the legal fraternity. Chairperson, our history is not short of women who are of positive influence, women who have held up justice as an embodiment of hope for an empowered future. Our history is littered with examples of great women who have contributed to the kind of society we have today. While some may have passed, they have left an indelible mark in our hearts and minds. Their strides have shaped the trajectory of our nation. And we say sincere condolences to the family of Comrade Chinajwa Peterson. We wish to pay a special tribute to women of strength like Mama Victoria Nomanyazelo Mngenge. Having practiced as a nurse, Mama Victoria obtained her law degree in 1981 from UNISA and joined her husband, Griffiths Mngenge's law firm in Durban. She was subsequently admitted as a lawyer. Tata Griffiths was brutally assassinated in November 1981, and she had to keep the law practice going and began to play a more prominent role as a human rights lawyer and a political activist. She defended victims of the apartheid system and became a fierce opponent of the state brutality and a beacon of light for the people of South Africa, including the youth, students, and members of other political formations. Victoria Mngenge and her husband bear the supreme prize for defending the rights of oppressed South Africans to exist in conditions of freedom, justice, peace, and democracy. We pay tribute to Mama Priscilla Jana, also a human rights activist and a personal attorney to former President Mandela. It is said that at one stage, she represented every single political prisoner on Robben Island. She served as a member of the South African Law Reform Commission, a member of the first democratic parliament, and was the deputy chairperson of the South African Human Rights Commission at the time of her passing. We pay tribute to Justice Yvonne Mokgoro, the first Black woman to serve on the Constitutional Court of South Africa. She contributed significantly to developing the country's legal system. Justice Mokgoro was awarded the Order of Baobab in Browns for excellent contribution in the field of law and administration of justice in the democratic South Africa. House Chair, having spent a considerable period in academia, Justice Kate O'Regan was appointed to serve as a judge in the newly formed Constitutional Court at the young age of 37. She served alongside with Justice Mokgoro as the only two women among 11 judges in the Constitutional Court in 1994. Indeed, it has taken longer for Black women to enter the profession. The struggles of women entering the legal profession have not been limited to race or class. They even transcend our borders. Women across the world have not been spared from gender discrimination. Moving further afield, even in the United States, entry into the profession by women was made difficult. We pay tribute to Judge Ruth Bader Ginsburg, the second woman and first Jewish woman to serve on the Supreme Court. She wrote the court's opinion in the United States versus Virginia case, ruling that qualified women could not be denied admission to the Virginia Military Institute. She is often quoted for her famous words, "Women belong in all places where decisions are made. It shouldn't be that women are the exception." House Chair, coming back home, we also wish to show our sincere appreciation to the former president of the Supreme Court of Appeal and current Deputy Chief Justice, Mandisa Maya. Her ascendancy to the highest excellence of the judiciary, to the police, and the responsibility of police officers to conduct themselves properly to foster the community's trust in the institution. The Constitutional Court upheld Justice Maya's judgment in F versus the Minister of Safety and Security. Chairperson, we express our sincere gratitude to Chief Justice Zondo for resuscitating the Aspirant Women's Judges Program, which was started by the first woman Minister of Justice in the democratic South Africa, Mama Bridget Mabandla, and amply naming the program after her. The Bridget Mabandla Aspirant Women's Judges Program aims to address the underrepresentation of women in the judiciary by creating a pool of which women judges can be appointed. Through this training program for aspirant women judges, women practitioners with potential to be appointed as women judges are identified, enrolled, and exposed to a specifically designed judicial education program to enhance their opportunity for appointment to the bench. We believe that this will yield many positive results and opportunities. Honorable members, nearly 100 years ago, former Chief Justice of the Orange Free State, Melesius de Villiers, in the South African Law Journal said, "It is absolutely most undesirable that women should be allowed to become practicing members of the legal profession." His remark only reflected the perspective held by many in the profession at that particular time. Another writer in 1917 called the objection to women in the legal profession a wholesome one, because the fact that women nurse, sew, and wait at canteens is no indication of their capacity for the legal profession. If there is one calling in the world for which women are conspicuously unfitted, it is the law. Women have no idea of relevancy or analogy or evidence. A century later, House Chair, we are pleased that we have moved forward as a nation. Women of this country have proven that both men are wrong. While much has been done to transform the profession and the industry, much still needs to be done. The lamentation of women cannot fail on deaf ears. We encourage more women to enter into the profession and to be given space, the necessary support to sustain themselves in the career. House Chair, let justice be done through the heaven may fall. I thank you.
I will say malibongwe. Kubo bonke abomama abakulezi zomthetho. Sibafisela okuhle more transformation for women in the legal fraternity. Thank you very much, honorable members. Honorable members, we will now go back to the decision of the question on the first order. Yes. The question before the House, honorable members, is that Mr. Errol Vincent Macherman be recommended for appointment to the Public Service Commission. Are there any objections to the nomination? Yes, remember?
House Chair, the DA calls for an a division.
No, the division is noted. Honorable members, in terms of section 196, did she? Oh, I didn't hear the part. Did you ask for the division? I'm sorry,
Yes,
I
ma'am.
didn't hear that part.
It's
I'm
all right.
sorry.
It's
Thank
all-
you.
I'm sure you're a little bit stressed. It's okay.
No, I'm okay. All right, then it's okay. The division having been asked, we will allow the bells to be rang for 5 minutes. I didn't hear that part.
Recording stopped. Recording in progress.
Thank you, honorable members. Order. The break is over. Thank you. Honorable members, the speaker has determined that in accordance with the rules A manual voting procedure will be used for this division. Firstly, in order to establish a quorum, I would like to request the table to confirm that we have requisite number of members physically present in the chamber and on the virtual platform to take this decision. We are okay. It's confirmed. Party whips will then be given an opportunity to confirm the number of their members present and indicate if they vote for or against the question. A member who wishes to abstain or vote against the party vote may do so by informing the chair. Honorable members, having confirmed that we have the requisite quorum, we will now proceed. The question before the House is that the House approves the nomination of Mr. Errol Vincent Macherman to serve on the Public Service Commission. Voting will now commence. The doors to the chamber will be locked and members will not be allowed to enter the virtual platform until voting is concluded. Even to leave the virtual platform, they are not allowed. Honorable whips, I hope you have counted correctly today. Could you confirm the number of your members present in the chamber and on the virtual platform and indicate if they vote for or against the question? The table will assist if needs be. The ICT will confirm the numbers of members that are on the virtual platform. Are you ready, party whips? Correct numbers? Thank you. The ANC.
Thank you very much, House Chair. ANC in plenary here physically is 53. ANC on a virtual platform is 150. That total up to 203 voting in full support. Thank you.
Thank you. The GA.
House Chair, in the House, there are 19 members. Online, there are 42 in total. There are 61 voting against this recommendation.
Thank you. The EFF.
House Chair, in the House.
Order, members, they have to hear the numbers correctly, please.
In the House, we have 6 members. And on virtual platform, we have 15, and in total, that's 21, and we are voting in favor. Thank you.
Thank you. The IFP.
The IFP is 6 on the visual, 4 in the House, and we vote totally against.
Thank you. The FF plus.
Thank you, House Chairperson. Online, we have 7 members. In the House, 1, that's 8 voting against.
Thank you. The ACDP.
Thank you, House Chair. 1 on the virtual platform voting against. Thank you.
Thank you. UDM.
1 on the virtual voting against, Chair. Thank you.
Thank you. The ATM. Abeko. Good.
House Chair, 1 on the platform and 1 in the House. So that's 2 voting in favor. Thank you.
Thank you. NFP.
Chair, 1 in the House voting against.
Thank you. AIC.
1 in virtual voting in favor.
Thank you. COPE. We missed COPE. Good to hear the voice from COPE.
Oh, thank you very much, Chair. COPE has 1 in the House
and we support. Thank you very much.
Thank you. Al-Jama,
One on virtual, we support.
thank you. Oh, the PAC, it was missed here. I'm sorry if I call you last. They missed you on my document. PAC? Abekone. Is that all? Are we okay? Thank you. Is there any member that wishes to abstain or vote differently to their party? None. The voting session is now closed. Thank you. Honorable members, may I remind the members that this vote is not a simple majority vote. This vote, you have to have 201 in favor. Thank you. Let me now read what the results are. Order, honorable members, no abstentions. Noes 82 and yes is 229. Honorable members, the question of the nomination of Mr. Errol Vincent Macherman for appointment to serve on the Public Service Public Service Commission is accordingly agreed to. May I request the order 3. May I request that the secretary reads order 3.
Consideration of request for approval by Parliament of agreement amending the SADC Protocol on Gender and Development in terms of Section 2312 of the Constitution, 1996.
Mar, to be honest, animzwanga no secretary. Kanumsindo ngewani namhlanje. Hayi asebelief. Ake siyehleni kancane tu. Let's be in the house, please. The Honorable Ndaba, Chairperson of the committee, please introduce that report.
Oh, okay. Thank you very much, House Chairperson, Honorable Chief Whip and Deputy Chief Whip, honorable members, good afternoon. According to Section 231(2) of the Constitution of the Republic of South Africa, 1996, an international agreement binds the Republic only after it has been approved by the resolution in both the National Assembly and the National Council of Provinces. South Africa signed the SADC Protocol on Gender and Development on the 17th August 2008 and ratified it on the 29th October 2012. The protocol entered into force on the 22nd February 2013. South Africa, therefore, has an obligation to comply with its commitments. The protocol was revised in 2016 so that its objectives are aligned to various global targets and emerging issues. To this end, some of these global targets are contained in the UN Sustainable Development, the SDGs, the African Union Agenda 2063, and the Beijing Declaration and Platform for Action. The agreement amending the SADC Protocol on Gender and Development provides for the empowerment of women, elimination of discrimination, and the promotion of gender equality and equity through gender-responsive legislation, policies, programs, and projects. In terms of the SADC Regional Indicative Strategic Development Plan 2020-2030, it is expected that all SADC member states must approve, ratify, and domesticate the SADC Protocol on Gender and Development. The Department of Women, Youth, and Persons with Disabilities and the Department of International Relations and Cooperation briefed the Portfolio Committee on Women, Youth, and Persons with Disabilities on the agreement amending the SADC Protocol on Gender and Development on the 30th of November 2021 and again on 8 November 2022. Given the substantive changes and new additions to the said protocol, the committee was briefed accordingly and deliberated extensively on the changes, hence the follow-up meeting. After being briefed and deliberated, the committee adopted the report on the 8th November 2022. I thank you, Honorable House Chairperson.
Thank you. I will now recognize the political parties wishing to make a declaration. The DA. My Honorable Machezi is Tulonasla.
Thank you. Thank you, Chair. The Republic of South Africa, a member of the Southern African Development Committee with the SADC, is eager to adopt this political declaration to promote the SADC's protocol on gender and development on the need to raise the age of marriage for girls to 18 in line with the SADC goals. South Africa is committed to promoting gender equality and equity. We believe that all people, regardless of their gender, have the right to live free from discrimination and violence. Child marriage is a violation of these rights. Child marriage is a widespread problem in the SADC region. According to UNICEF, 1 in 3 girls in the SADC regions are married before the age of 18. It is a major obstacle to the region's development. Girls who are married before the age of 18 are more likely to drop out of school, experience violence, and become pregnant as teenagers. They are more likely to live, and also they are more likely to live in poverty. Raising the age of marriage to 18 is an essential step to ending child marriage. It is clear and an unambiguous message that child marriage is not acceptable. It also sends a strong signal to parents and communities and religious leaders that child marriage is harmful and should not be tolerated. South Africa is committed to taking action to raise the age of marriage to 18. We have already enacted a legislation that sets the minimum age of marriage at the age of 18 for girls. We also call on all SADC countries to take action to raise the age of marriage to 18. This is a critical step to ending child marriage and ensuring that all girls have an opportunity to reach their full potential. We therefore, as a Democratic Alliance, support this move. Thank you.
Thank you. The EFF. Allow Umam Kaula enze umsebenzi wakhe. Allow her, please.
Ngibonge Chair, Leli komiti esihlala kulona linenkinga. Asikwazi ukulisupporta kule bill yalo. Ngiyabonga ukusho. Sineyinkinga eziningi zamacala avulwayo ngokwe rape ngabantu abafileyo othola ukuthi lamacala isikhathi eside akuhlala emakhoti elokhu ehlehla abanye uthola baze bakuthi laba bantu abama victim baze babuye back bazobabulala ngenxa yabaseshi ngenxa yezinkantolo engafuni ukwenza umsebenzi wazo. Ngizelane Western Cape ningangishayi bafethu. La Western Cape kunenkinga enkulu. Kunabantu abasebenza emaplazini la Cape Highlands. Kunezinkubela esayithola kuyilento ka May 1 lana abantu khona abashawayo emaplazini umlungu ngoba mhlambe befuna imali yabo efanele. So labo belungu mabevula amacala baboshwa akalandelwa kusasebenza lento yebala elimhlophe. Ehowick what ugogo Mulive una 86 years oshawe umlungu uGerard ngoba umlungu akaboshiwe kunoma aboshwe icala liyahlehla ngangokuthi abaseshi angazi noma bayagwazelwa yini bagcina sebenza njani beshiya bengayi kwi-court. Yebo eLimpopo ePharabowa Ward 7 and Ward 9 amanzi awekho lapha for 10 years ompompi ba empty omama bayareshwa beyokha amanzi emasimini.
Order, honorable members, please lower your noise.
I'm not playing here.
Yeah, you are not, Ma'am Kaula, you are not playing. Please, members, let's give each other the respect that everyone deserves.
Lolu sizo lubhekene nabantu bakithi abamnyama la eSouth Africa. Lana sinenkinga yama-court. La sinenkinga yamajaji. Umuntu mayefile siba nenkinga ukuthi icala lakhe kuphelele emoyeni. Kukhona into ke ngihlezi ngiyicula. Le yama body party. Le yanto ugovernment naye unesandla. Ngoba kufanele ngabe lezi zinyanga ezingoqhibukhowe. Okuyizona ezithembisa abantu ingcebo. Abantu bafaka ngaka nje through bona kuthathwa ama body part. Okunye okubuhlungu kakhulu yileyo ukuthi mangabe kufe umuntu omnyama la eSouth Africa akukho la kuthiwa nangu seboshiwe kuthusa phenywa kusaphenywa kodwa ke kube webala manje seboshiwe. Yizo ke lezi zinto esithi if lemnyango ekhona ingakakwazi ukusebenza ngendlela ngeke sikwazi ukuyiphasisa le budget. Ngiyakamhlaba iyalingana manje. Kamhlaba iyalingana. Ngikhulumela abantu besifazane nezingane. Kamhlaba iyalingana kunendawo lapha yami eyichoba noma ngathi eyisiqiwu. Le ndawo ngakhuluma ngayo la ngifika ngo-2015 ukuthi le ndawo abantu bakhona makuzovota kuyaziwa lapha kunabantu abareshwayo kunezinkubela lapha ya kodwa izingane zabo mangabe zizezikoleni ziwela ngapha akekho oyayo lapha ayobheka.
Thank you, Ma'am Kaula, ngikuphe imizuzwana eminingi.
100
Honorable Ma'am Kaula. Isikhathi sesidlulile, ma'am.
Kwasetshenzwa nje ngoyisupporta le budget.
Yes, thank you. Thank you, Honorable Kaula. Your time is up. Thank you. Order, honorable members. No, don't worry about that, please. Can we have order as I call on the IFP? Ma'am. I saw umam Avela lapha ku screen. Is she supposed to speak? Ma'am Sengwa?
Honorable Chair.
Order. Proceed,
Thank you, Chair.
Yes.
Thank you. At the moment, I am at the dilemma of the network, but I'll try.
We can hear you very well, ma. Proceed.
Thank you. Honorable Chairperson, our country constitution provides a framework for the promotion of gender equality and contains several provisions that advise this cause. Furthermore, the Bill of Rights guarantee equal treatment for all South Africans. The World Bank states that no society can develop sustainable without supporting opportunities, resources, and choices for both men and women, so that they have equal power to shape their own lives and contribute to their families, community, and countries. Article 4 of the SADC Protocol on Gender and Development has been amended to state that state parties shall develop and strengthen specific laws, policies, and programs to achieve gender equality. Our country has a shortage of legislation aimed at gender equality. However, over the years, it has become quite evident that our government lacks of the will to effectively implement these pieces of legislation, unfortunately. It seems as though our government still consider women's issue as soft issues. Article 20 was amended to read that state parties shall enact and enforce legislation prohibiting all forms of gender-based violence and shall develop strategies to prevent and eliminate all harmful society and cultural practices. In addition, state parties should ensure that perpetrators of gender-based violence are tried to a court to compete judicial. However, last week, we heard that South African women continue to bear the brunt of violent attacks. In the first 3 months of the 2023, more than 10,000 women were raped, more than 1,000 attempted murders of women were reported, 969 women were killed, and over 15,000 women were assaulted. In conclusion, Chairperson, considering these statistics, South Africa should greatly benefit from embracing the amendment SADC Protocol on Gender and Development.
Thank you, ma.
Therefore, the IFP support the report.
Thank you.
Thank you.
FF Plus.
Thank you, Honorable Chair.
The revised SADC Protocol on Gender and Development provides for the empowerment of women, elimination of discrimination, and the promotion of gender equality and equity through gender-responsive legislation, policies, programs, and projects. The development
Mam Shengwa, sewuqedile ukukhuluma ungathi ungayivala. I'm sorry, Honorable Dana. Is it Brett? Briet, yeah.
It's
Honorable,
Briet, ma'am.
Yes, Honorable Briet, I'm sorry for that. I'm going to allow you to start. And this is a condition that even in the House, please lower your voices. I can hear what you are saying from where I'm sitting. I don't want that. Can you restart, Ms. Dana, please? Thank you. Ms. Dana,
Yes.
please.
Thank
Proceed.
you, Madam Chair. The revised SADC Protocol on Gender and Development provides for the empowerment of women, elimination of discrimination, and the promotion of gender equality and equity through gender-responsive legislation, policies, programs, and projects. The protocol was revised in 2016 so that its objectives align to various global targets. Some of these targets are contained in, for example, the post-2015 UN Sustainable Development Goals, to name but one. SDG Goal 5, for example, deals with the promotion of gender equality and empowerment of all women and girls and sets 9 targets that need to be met by the global community by 2030. These include ending all forms of discrimination against women and girls, elimination of all forms of violence against women and girls in the public and private spheres, including trafficking and sexual exploitation, and ensuring the full and effective participation of women and equal opportunities for leadership at all levels of decision-making in political, economic, and public life. In addition, the revised protocol captures emerging issues such as climate change and child marriages. What is, however, necessary to understand is that one cannot legislate women into equality. It starts out by ensuring that girl children are given equal opportunities and do not miss school because of menstruation, for example. The only way in which women will truly rise up and be equal is by ensuring there are equal opportunities. I thank you.
Thank you, Ms. Brett. We now move to the ACDP.
Thank you, House Chair. House Chair, the ACDP supports this report, given the high levels of human trafficking and other issues affecting women in the subcontinent. And we welcome the fact that the age for marriage has been lifted to 18 in terms of our own legislation. I think the only concern relates to the time it takes for Parliament to consider such international agreements. And Chair, if one considers that Section 55 sets out that the National Assembly must hold the National Executive to account by exercising oversight, and then Section 231 indicates that such international agreements are only taking effect once they are approved by the National Assembly and the NCOP, then this raises the question as to what happens once the executive signs these agreements until Parliament ratifies them. Chairperson, I think this is an issue which we as Parliament need to look at very carefully in exercising our oversight. However, having supported this report, I do wish to allude again to the related issue, and that is treaties that are presently being negotiated where Parliament has no oversight, and that is the World Health Organization's pandemic treaties. We need to be aware of what is happening in these regards, as in our view, they have a direct impact on the competencies of sovereign nations, which could be handed over to the World Health Organization and which require parliamentary oversight, given that the World Health Organization does not have a democratic mandate and that it could have more power than national governments in such key areas as national health, where words such as may in the past now are to be replaced by must, which are obligatory. So we trust that going forward, that Parliament will be able to exercise its ratification and oversight over such international treaties far quicker than given the impact of such international treaties. And just to repeat, the ACDP will support this report. I thank you.
Thank you. UDM. Sesekhona UDM. ATM. Good,
House Chair, we support the amendment of the agreement. Thank you.
thank you. NFP. Ayikho. AIC,
We support the report, Honorable Chair.
thank you. COPE,
We support. Thank you very much.
thank you. PAC. Al-Jama. The ANC.
Honorable House Chair, Honorable House Chair, Honorable Chief Whip, Honorable Deputy Chief Whip, Members of Parliament, and fellow South Africans. The ANC fully supports the approval by Parliament regarding the agreement amending the SADC Protocol on Gender and Development, as contained in the Portfolio Committee report, and recommends that the House, in terms of Section 231 of the Constitution of the Republic of South Africa, Act 108 of 1996, approve the said agreement. The protocol aims to empower women, eliminate discrimination, achieve gender equality and equity through the enactment and execution of the appropriate legislation, policies, programs, and projects by participating member states. The area of conflict which hinders a timely adoption of the amendment are on Article 8 of the SADC Protocol, focusing on child marriage, which was amended to provide for outright prohibition of underage marriages. The new text reads as follows: no person under the age of 18 shall marry, full stop. The Portfolio Committee referred the matter for further consultation by the Department of International Relations and Cooperation, the Department of Women, Youth and Persons with Disabilities, and the Office of the Chief State Law Advisor to find a way in ensuring Parliament approves the protocol, as legal considerations had to be taken by the various departments. In finalizing the matter, House Chair, including requesting the President's guidance, the Portfolio Committee has considered the fact that South Africa is already party to various international obligations, and which are related to SADC amendments, to amendment of the protocol related to marriage as such. The African Charter on the Rights of and Welfare of the Child, which expressly prohibits such marriages and became binding on South Africa upon ratification on the 21st January, the year 2000. That will be found on Article 21. The Maputo Protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa, that provides in Article 6b that the minimum age of marriage for women shall be 18, and was ratified by South Africa on 17 December 2004. The United Nations Convention on the Elimination of All Forms of Discrimination against Women, to which South Africa became party on the 15th January 1996, obliges state parties in Article 2A to include the principle of equality of men and women in their constitutions and legislation. And in Article 16A specifically obliges state parties to ensure the same rights to men and women to enter into marriages. Therefore, House Chair, the SADC Protocol on Gender and Development can be adopted, but we need to expedite the review of marriage policies and legislation to align with the protocol. The Department of Home Affairs has developed a white paper on marriages in South Africa to lay a foundation for national policy aimed at enacting laws that are grounded on the principle of equality and address non-discriminatory marriages. The white paper was approved by Cabinet in March 2022, and we await the legislative amendment as Parliament. House Chair, this is an important protocol we are passing, which will introduce legislation which only permits marriages for persons over the age of 18. This will protect vulnerable children who have been forced to leave school and advancing their own development due to marriage below the age of 18. The African Union Agenda 2063 envisions a more inclusive society on the continent where all citizens actively participate in decision-making processes without being excluded based on factors such as gender, political affiliation, religion, ethnicity, locality, or age. The ANC supports the report, House Chair. I thank you.
I thank you. Thank you, honorable members. Order. Are there any objections to the approval of agreement amending the SADC Protocol on gender and development as it appears on the order paper?
Yes, Chair, please note the objection of the FF Plus.
Thank you. With that objection, this report is agreed to. Thank you. May I now ask the secretary to read the last order?
Consideration.
Wait. Julle moet almal luister waaroor ons praat. Asseblief. Kanan?
Consideration of request for approval by Parliament of amendment to Article 20, subsection 1 of the Convention on the Elimination of all forms of discrimination against women in terms of Section 231, subsection 2 of the Constitution.
Thank you. Honorable Ndav, Buya, who platform, who introduce the report.
Thank you very much, House Chair. Mam Kaula, it's not a budget. We were presenting SADC Protocol. Honorable Thengwa, we were presenting SADC Protocol. What you were presenting is CEDAW. So the report that you are presenting, you must come present it now. Thank you very much, Honorable House Chair. The Convention on the Elimination of all forms of discrimination against women is an international legal instrument that requires countries to eliminate discrimination against women and girls in all areas and promotes women and girls' equal rights. It was adopted in 1979 by the UN General Assembly and entered into force on the 3rd September 1981. Subsequently, a committee of CEDAW was established that monitors the implementation of the convention by member states. South Africa signed the convention in 1993, and on the 15th of December 1995, our parliament ratified without any reservation the convention. In March 2005, the optional protocol to CEDAW was also ratified without reservations. The Committee on the Elimination of Discrimination Against Women is the body of independent experts that monitors implementation of the convention in all forms of discrimination against women. The CEDAW Convention has been ratified by 165 countries, making it almost universal. This illustrates the importance of women and development globally by member states. Hence, the committee has a very important role to play and requires sufficient time to do its work in order to give effect to its mandate. The proposed amendment, Article 20, subsection 1, seeks to introduce a procedure that allows for a more flexible time allocation for the meetings of the committee that monitors the convention. Article 20, subsection 1 of CEDAW provides that the committee shall normally meet for a period of not more than 2 weeks annually in order to consider reports submitted in accordance with Article 18 of the Convention. Due to the increased workload of the committee because of more state parties ratifying the convention, the General Assembly adopted a resolution to amend the Article 20 in 1995 to increase the duration of the committee's meetings. The proposed amendment places the words, and I quote, "not more than 2 weeks annually," I close quote, "with the committee shall normally meet annually in order to consider the reports submitted in accordance with Article 18 of the present convention. The duration of the meetings of the committee shall be determined by a meeting of state parties to the present convention, subject to the approval of the General Assembly. The amendment of the Article 20, subsection 1 of the Convention on Elimination of all forms of discrimination against women was referred to the Portfolio Committee on Women, Youth, Persons with Disabilities in October 2022. The request for approval of the proposed amendment is in terms of Section 231, subsection 2 of the Constitution of the Republic of South Africa, number 108 of 1996. Subsequently, the Department of Women, Youth and Persons with Disabilities and the Department of International Relations and Cooperation briefed the Portfolio Committee on Women on amending Article 20, subsection 1 on CEDAW on 8th November 2022. After being briefed and deliberated, the committee adopted the report. I thank you, House Chair.
Thank you. I will now recognize political parties that wish to make declarations. I'll start with the DA.
Thank you, House Chairperson. Greetings to the Honorable Chief Whip and Deputy Chief Whip of the official opposition and incoming government of 2024. Honorable members.
Honorable
Hello, Chief Whip.
Honorable Sharif, those gestures are unparliamentary. I'm just protecting you.
Thank you for the protection. House
Proceed.
Chair. Chair, the status of women in the country, the region, and globally continue to make strides, but remains limited when looking at the reality that so many women continue to face every single day. It is common knowledge that the fight for gender equality is not only a fight that women must take up, but one that requires a whole of society approach. The Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, was adopted in 1979 by the UN and is often referred to as the International Bill of Rights for Women. Being a signatory to various international treaties like CEDAW means that South Africa has the responsibility to participate, facilitate implementation in the country, and contribute to these bodies in the interest of women. State parties commit to ensuring that they take various measures to end all forms of discrimination against women and take steps to ensure that there is a national agenda of action to end discrimination against women. The CEDAW committee is a body of experts on women's rights, as our chairperson mentioned, and is responsible for the monitoring and the implementation of the convention, as well as consideration of reports from state parties, as well as communication from individuals or organizations that submit claims of violations of the convention, and provides the basis for the realization of equality between men and women. In terms of the amendment, House Chair, the amendment is on the amount of time the CEDAW committee will be meeting annually to do their work. The work done by CEDAW committee is important work, and with the increased workload, only having 2 weeks to meet annually proves to be constraining and limiting in the amount of work that they are able to get through. The implication of this amendment is that instead of being limited to only 2 weeks a year, it will now be determined by state parties subject to the approval by the General Assembly. Therefore, the proposed amendment would allow for more flexible time allocation for the meetings of the committee. House Chair, a concern around this is that in the Portfolio Committee, the DG of the Department of Women, Youth and Persons with Disabilities argued that the acceptance of this amendment would depend on how many other member states had signed the amendment. South Africa needs to be decisive and lead from the front. The work we do every day in South Africa to realize equality must be increased and it must be prioritized. In order to realize a society where equality is common practice, we must do more to ensure women are safe, women have access to job opportunities, education, healthcare services, and essentially trust in government and its entities. We should not only rely on international treaties to fight against discrimination. We must work on fighting against discrimination in our borders every single day. The DA agrees with the report by the Portfolio Committee. I thank you.
Thank you. The EFF?
Declaration, but to say support.
Thank you very much. The IFP? The IFP?
Thank you,
Mamlewa?
Chairperson. Yes, thank you, Chairperson. Apology for opening the mic last time.
Problem, proceed, ma.
Yes. Honorable Chairperson, our country's constitution provides a framework for the promotion of gender equality and contains several provisions that absent this cause. Furthermore, the Bill of the Rights guarantee equal treatment for all South Africans. The World Bank stated that no society can develop sustained
Abakumanzi mama. Sisastopile isikhathi sakho akophuza amanzi.
Nginomkhuhlane.
Yeah.
Thank you. Article 4, the SADC Protocol on Gender and Development has been amended to state that state parties shall develop and strengthen specific laws, policies, and programs to achieve gender equality. Our country has no shortage of legislation. Our government lacks to will to effective implement these pieces of legislation. Unfortunately, it seems as though our government still consider women's issue as soft issues. At Article 20 was amended to read that state parties shall elect and enforce legislation prohibiting all forms of gender-based violence and shall develop strategies to prevent and eliminate harmful society and cultural practices. In addition, state parties should ensure that perpetrators of gender-based violence are tried by a court of competent jurisdictions. However, last week, we heard that South African women continue to bear our brunt of violence attacks. In the first 3 months of 2023, more than 10,000 women were raped, more than 1,000 attempt murders of women reported, 969 women were killed, and over 15,000 women were assaulted. In conclusion, Chairperson, considering these statistics, South Africa should greatly benefit from embracing the amendment SADC Protocol on Gender and Development. Therefore, the IFP accepts the report. Thank you. FF plus.
Thank you, House Chair. The Convention on the Elimination of All Forms of Discrimination Against Women is an international legal instrument that requires countries to eliminate discrimination against women and girls in all areas and promote women's and girls' equal rights. True equality, and not just the window dressing of equality, is very important. For society to truly move forward and ensure that girl children have equal opportunities, we need conventions such as this that shines the light on injustices being faced in a world that is becoming more violent and where GBVF is rife. This article currently limits the duration of the meetings of the committee to 2 weeks annually, despite the increase in the workload of the committee due to, amongst others, the increasing number of states ratifying the convention. The proposed amendment seeks to introduce a procedure that allows for a more flexible time allocation for the meetings of the committee. A more flexible time allocation for meetings will ensure the committee can allocate more time to important matters and do their due diligence. The FF Plus will support this report.
Thank you. ACDP.
Thank you, House Chair. The ACDP supports the report and won't be making a declaration. Thank you.
Thank you. UDM. ATM. Good.
House Chair, we support the amendment. Thank you.
Thank you. NFP. AIC.
Chairperson, we support the declaration without any declaration, with the report without any declaration.
Thank you. COPE.
Thank you, Chair. COPE support.
Thank you. PAC. Al-Jama. The ANC.
Honorable Chairperson of the House Chair, Honorable Chief Whip, Honorable Deputy Chief Whip, honorable members of the House, fellow South Africans. The ANC fully supports the request for parliamentary approval regarding the amendment of Article 21 of the Convention of the Elimination of All Forms of Discrimination Against Women, CEDAW, which is often referred to as the International Bill of Rights for Women. The emancipation of women remains a fundamental goal and core principle of the free and democratic South Africa. The ANC is committed to uniting all South African women, regardless of their diverse experiences based on race, class, ethnicity, religion, or demographics. Given the historical oppression faced by women, especially Black women, the ANC's focus remains steadfast on working class and rural poor women. The recommendation is made accordance with Section 231(2) of the Constitution of the Republic of South Africa, Act 108 of 1996, that an international agreement binds the Republic only after it has been approved by a resolution in both the National Assembly and the National Council of Provinces. The proposed amendment seeks to extend the duration of committee meetings responsible for processing member states' report. Meetings will no longer be limited to 2 weeks per annum, but will be determined by the state parties subject to the approval by the General Assembly. South Africa signed the Convention of the Elimination of All Forms of Discrimination Against Women in 1993 and ratified it in December 1995. The submission to Parliament aims to align the previously ratified convention with the amendment to Article 21 of the convention. This effort will contribute to strengthening the policy and legal framework, as well as the implementation of laws and policies that positively impact the lives of women and girls. It provides an opportunity to integrate the gender equality agenda and concrete plans for accelerated action into national development plans and objectives. By November 2021, only 20 state parties had accepted the amendment to Article 21(1), whereas 126 state parties are required to accept the amendment to bring into force. This then places significance in the House adopting this report, as this contributes to our intervention efforts of advancing gender equality and advancing an equitable world which promotes the rights of girls and women. Upon approval by Parliament, the Minister of International Relations and Cooperation will sign an instrument of acceptance on behalf of the state for deposition to the United Nations by the Department of International Relations and Cooperation. As a nation, we remain committed to the advancement of progressive ideals to protect women, particularly women in war-torn countries who are the victims of conflicts in the world and in the continent. We remain committed to address the economic inequality between women and men and call for the suitable distribution for the political economy. We call for the closing of the pay gap between men and women. As a nation, we have undertaken a focused approach to combat gender-based violence and femicide through a national strategy plan to be implemented by all social partners. The socio-economic transformation of women requires a transformation of culture, a transformation in ideologies, a transformation of thinking. Empowering women in South Africa involves addressing the legacy of apartheid and transforming society, particularly power relations between women, men, institutions, and laws. This amendment is a positive step in enhancing the work of the body that addresses gender oppression, patriarchy, sexism, racism, ageism, and structural oppression. It aims to create an enabling environment that empowers women to take control of their lives. Empowerment is viewed as active citizenship and equal participation of women and men in all aspects of life. The ANC key policy documents firmly reject discrimination against women in all forms. Both constitutions recognize women as equal citizens with equal rights and responsibilities. The ANC has played a leading role in women's struggles by advocating for non-sexist society and institutionalizing gender equality and women's empowerment through policies, institutional arrangements, and intervention measures. We support this report as part of our commitment to internationalism for the equal world. Thank you, Chairperson.
Thank you. Order, honorable members. Are there any objections to the approval of the amendment to Nieman? Ons doen dit nie so nie. You must listen to what you are agreeing to, please. Are there any objections to the approval of the amendment of Article 21 of the Convention on the Elimination of all forms of discrimination against women, as it appears on the order paper? Why is okay, honorable members, no objections agreed to. Honorable members, I'm going to request you to stand and wait for the chair and the maids to leave the chamber. That brings ons ten einde van die besigheid van die dag en die huis is verdag. What's happening with